What if the quietest person in the courtroom held the power to bring the whole system to its knees? This isn't politics. This isn't business. This is personal. The courthouse steps echoed under Barron Trump's shoes as he walked inside with an expression that gave nothing away. Tall, poised, and silent, he looked more like an observer than a participant. And yet today, he was neither. Today, Barron Trump was stepping into a fight. The courtroom was already filling with murmurs as people recognized him, the son of a former president, a political symbol. But to Barron, all that meant nothing today. Today wasn't about legacy, it was about loyalty, and he wasn't here to defend himself. He took a seat at the defense table next to a graying man in his 60s, a lifelong mentor and family friend named Martin Keene. A small-time contractor accused of regulatory violations so vague they barely made sense. But the fines were real, and the smear campaign had already started. Someone wanted to make an example out of Martin, and Barron wasn't about to let that happen. Across the room sat Judge Marla Whitlock, flipping through a file. Her reputation preceded her, a stickler for rules, but with a habit of bending them for political ends. She had ruled against conservatives in 27 out of her last 28 administrative hearings. Today, it seemed, would be no different. Barron said nothing. He didn't need to, not yet. His calm demeanor didn't reflect inaction. It reflected preparation. He had read the case file twice, memorized every line of the cited statute, and quietly he had prepared for this moment with a depth most people would overlook. The courtroom would learn soon enough. Silence wasn't weakness, it was strategy. She thought he wouldn't fight back. She didn't know who she was dealing with. The session began with formalities that passed like fog. Judge Whitlock's voice cut through the stale courtroom air with practiced authority. The matter of Martin Keene versus the city is now in session. Beside him, Martin exhaled slowly. Barron nodded to him once, reassuring without words. The city attorney, Amanda Reyes, stood. Her tone was confident, almost smug. She launched into her presentation with a stack of documents that hadn't been previously disclosed. Barron's eyes narrowed ever so slightly. "Objection, Your Honor," he said, his voice calm but firm. "This evidence was not submitted during discovery." Whitlock didn't blink. "Overruled. Let's proceed." Just like that, the rules had shifted. The evidence was flimsy. Satellite photos taken weeks after the alleged infraction, unverified third-party reports, and a typed memo with no signature. But Reyes presented it like it was gospel. Whitlock nodded along. Barron remained still, watching, calculating. They were trying to overwhelm with quantity, not quality. It was an old trick. And it only worked if the other side panicked. But Barron didn't panic. He listened, and he waited. He knew when the time was right, his words would carry more weight than their stack of paper ever could. One objection could change the course of this trial, but only if it's heard. When the city finished presenting its so-called evidence, the judge turned to Barron. "You may respond," she said, already sounding dismissive. Barron stood slowly. He walked toward the center of the courtroom with a stillness that commanded attention. No notes in hand, no hesitation. "Your Honor," he began, "the city's case rests on 3 forms of evidence. Let's examine them, one by one." He started with the satellite photo, pulling it up on the court screen. This image, dated 3 weeks after the alleged violation, proves nothing except that time has passed. There is no timestamp correlating to the incident, no context, no location markers. It could be anyone's property. He moved on to the unsigned memo. This document, notarized by no one, signed by no one, was typed, printed, and submitted as if it carried weight. It doesn't. In any other court, this would be inadmissible. Finally, he addressed the third-party report. A report submitted by an organization that, upon investigation, turns out to be funded by the same city department bringing this case. That's not independence. That's collusion. He paused, letting silence speak for him. We are not here to play dress-up with due process. This is a legal proceeding. And if we're going to pretend to respect the law, then let's actually do it, the gallery murmured. Even Judge Whitlock shifted in her chair. For the first time, Barron wasn't just seen, he was heard. The judge ruled with authority, but Barron brought something more powerful, truth. Judge Whitlock cleared her throat, her eyes narrowing as she adjusted her glasses. Mr. Trump, this court does not appreciate grandstanding. Barron didn't flinch. Neither does it appreciate impropriety, or it shouldn't. A beat passed. You could feel the temperature in the room drop. Barron turned and faced the gallery, his back momentarily to the judge. Let's be honest with ourselves. This isn't about a zoning violation. This is about influence, about optics, about putting on a show that says, no one is above the system, except, of course, those pulling its strings. He turned back. Your Honor, I don't say this lightly. This case is politically motivated. A collective intake of breath swept the room. Even Martin looked up, eyes wide. Whitlock's voice was colder now. You tread on dangerous ground, Counselor. Barron stepped forward, not in defiance, but in precision. I tread on ground that's already crumbling, Judge. I'm just calling it what it is. He let that sit, and he saw it, the flicker in her eyes. Not fear, not anger, recognition. She knew he was right, and that made her dangerous. When the system protects itself, who defends the innocent? The courtroom doors creaked open and closed as Judge Whitlock abruptly called for a 15-minute recess. The gavel had barely struck the bench before she disappeared behind chambers. The silence she left behind was louder than anything she had said. Barron sat still, fingers resting lightly on the polished surface of the defense table. He wasn't surprised, not even rattled. Recesses like this weren't pauses, they were power plays. A moment to realign, to scramble behind closed doors, to strategize. Martin leaned in, whispering, Do you think she's stalling? Barron didn't look away from the bench. She's regrouping. We hit something. Now she needs time to decide how hard to push back. Just then, an aide approached, not from the court, but from the city attorney's office. She handed Barron a small envelope and walked away without a word. Inside was a note, handwritten, short, direct. Settle now. Walk away. We let this go quietly. Barron didn't smile. He folded the paper, placed it in his briefcase, and leaned back in his chair. They weren't doubling down because they were confident. They were doing it because they were cornered. And the moment they offered peace, Barron knew he had no intention of accepting it. They gave him an out. He chose the fight. When Judge Whitlock returned, she wasn't alone. Trailing her was a man whose presence stilled the air in the courtroom, Justice Franklin Reeve. Older, taller, and more composed than anyone in the room, his silver hair and solemn expression gave him the aura of someone carved from the judiciary itself. Barron recognized him instantly. Everyone did. Reeve wasn't just a judge. He was a symbol of old guard federal power, reserved for emergencies or appearances. Whitlock took her seat and adjusted her mic. For the record, Justice Franklin Reeve has joined these proceedings in an advisory capacity. Barron turned slightly, just enough to show he was unimpressed. The room was shifting, and they hoped Reeve's presence would tip the scale, but Barron welcomed it. Justice Reeve addressed him directly. Mr. Trump, you've raised concerns of procedural violations, legal inconsistencies, and political conflict. I would ask that you substantiate your claims clearly and specifically. Barron nodded. With pleasure, Your Honor. They brought reinforcements. He brought receipts. The city's lead enforcement officer took the stand. Sergeant Harris Loomis, a veteran of the department, his face stone-set, his uniform pristine. He adjusted his collar and stared forward like a soldier ready to defend a castle. Barron approached slowly. Sergeant Loomis, can you confirm you issued the violation against my client? Yes, I can. And on what basis did you make that determination? Observed code infractions, documented during routine inspection. Barron paused. Documented how, exactly? Loomis hesitated. In my report. Photographs? No. Signed witness statements? Video? Third-party validation? None were necessary. I've been doing this job 25 years. I know what a violation looks like. Barron turned to the bench. So this court is expected to accept a $35,000 penalty based solely on an officer's opinion, without a shred of objective evidence? Whitlock opened her mouth, but Reeve raised a hand. Let him continue. Barron stepped closer to the witness stand. Sergeant Loomis, are you aware that under case law, specifically Hollins v. City of Oakland, administrative penalties without evidentiary proof are inadmissible under procedural review? Loomis blinked. No, I wasn't. Then let me educate you. He turned to the court. We are standing in a room where fines are issued without evidence, where careers are threatened by unchecked authority. And now you bring in a federal judge to validate it? If we're going to make this about rules, let's at least follow them. Truth doesn't need volume. It needs verification. Justice Reeve leaned forward, hands clasped. Mr. Trump, are you suggesting that not only was this fine issued in error, but that the entire process surrounding it is legally compromised? Barron didn't blink. I'm not suggesting it. I'm stating it. Reeve nodded slowly. Then please clarify. Barron walked to the front of the court, standing in the open. Subsection 14.3b of the Administrative Code requires all municipal violations to be supported by photographic or third-party evidence. This was not done. The officer confirmed it. He picked up a small packet of papers and placed them in front of the judges. Here are 3 precedents: Benton v. Chicago, Lowe v. City Board, and Sullivan v. State of Illinois. Each overturned for the same reason: no evidence, no process, no legality. Reeve scanned the papers. Whitlock remained stone-faced. Barron didn't stop. This court does not have the authority to selectively enforce the law. It must uphold it, or admit it has failed to. The gallery stirred. Even the prosecution began to whisper among themselves. Barron turned one last time. You brought me here hoping for surrender. What you got was scrutiny. What you wanted to silence just found its voice. Every pillar of the case was about to fall, and Barron had the sledgehammer. The tension in the courtroom was now a living thing, thick, silent, breathing. Judge Whitlock's fingers tapped the bench with a rhythm that betrayed her frustration. Justice Reeve sat still, reading through the precedents Barron had laid before him. Then, just when it seemed the court would concede, Whitlock leaned into her microphone. Despite the compelling arguments, this court retains discretion in matters of administrative review. The fine, therefore, will stand. A collective gasp. Martin's shoulders sagged. Even Justice Reeve looked sideways at her. But Barron didn't blink. He remained standing, calm, resolute. Then, with deliberate poise, he turned to the court stenographer. Could you please read back the judge's last statement? She did, word for word. Barron faced Whitlock again. So to be clear, you're stating that a municipal fine can be enforced without evidentiary proof, and that this court recognizes that as lawful. Whitlock bristled. This court has discretion. Barron nodded. Discretion, Your Honor, is not immunity from legal standards. He turned to the gallery. What message are we sending? That any officer at any time can issue a fine without proof, and the only answer the people get is, the court has discretion? That's not rule of law, that's rule by fiat. Justice Reeve shifted. The words had weight. and Whitlock knew it. Barron wasn't just defending Martin Keene anymore. He was defending the principle that power must be bound by proof. They tried to bury the rules. Barron used their own words to dig them up. Justice Reeves spoke for the first time in minutes. Judge Whitlock, in light of the presented precedents and the absence of admissible evidence, I advise the court to reconsider its position. Whitlock said nothing. Barron stepped forward one last time. This case is no longer about one man or one mistake. It's about a process that's drifted too far from the law it claims to uphold. Today, you get to decide whether the bench is a seat of justice or a shield for unchecked power. The courtroom was silent. Whitlock's jaw tightened. Her gavel hovered in her hand. Then Reeve turned to her. "Judge Whitlock, I concur with the defense." There it was. Her fingers curled. Her pride flared, but she knew the truth had won. The court finds the imposed fine unenforceable due to lack of evidentiary support. The penalty is hereby overturned. The gavel dropped. The sound echoed like a final bell. Martin closed his eyes, relief flooding his face. Barron simply gathered his papers, stood tall, and turned to leave. But then, "Mr. Trump," Whitlock said. He stopped, turned. For the first time, her voice lacked force. It carried something else. Resignation, maybe even respect. "I underestimated you." Barron gave her the faintest nod. "You wouldn't be the first." And then he walked out. In a courtroom that expected him to stay silent, Barron Trump rewrote the rules. Not by shouting, not by force, but by making the law do what it was always meant to do: protect the truth. Today, one fine was overturned, but tomorrow 1,000 more might be challenged because of it. Do you think courts should be allowed to rule without evidence? Should a judge have unchecked discretion? Let us know in the comments. And if you found this story as powerful as we did, don't forget to like, subscribe, and hit that bell so you never miss another fight for justice that starts with just one voice.